understanding of the system. And as I write in my paper, we moved from a sexual misconduct paradigm to what I term the equality-based paradigm of harassment. And just to give context regarding the importance of this shift, I'm going to state some figures. According to World Bank report, about 48 million women are out of the workforce in Pakistan. The labor participation rate for women in Pakistan is just a little over 25% when the global average is over 47%. 1 in 3 women feel unsafe in the public, and the pay differential between various professions in Pakistan between men and women ranges from 17 to 20%. And the very objective of this act, when it was promulgated, was to address this discrimination against women in the workforce and the exclusion of women from the workforce. We look at the statement of objects and purposes of this act, and it's quite clear that the purpose was to ensure working environments for women where, number one, they can work in a safe and dignified manner, safe from instances such as sexual harassment, but also, as importantly, to be working in environments that are non-discriminatory, where they're given equal opportunities with men. When we, however, look at the definition clause of in this act regarding harassment, ostensibly it appears more limited to sexual forms of misconduct. So it includes unwanted sexual advances, requests for sexual favors, verbal or written communication of a sexual nature. But sexual misconduct is only one aspect of the structural exclusion and discrimination against women in the workplace, which may manifest in different ways. It may manifest in the form of questioning female employees' ability and professionalism on the basis of her gender, not according her the same pay as a man in the same line of work, restricting her growth opportunities, her opportunities to learn, for instance. So these forms of conduct, or this culture at the workplace, is as responsible for excluding women from working environments, from the labor force, as is sexual discrimination. And this is why the shift in paradigm is so important, because it reflects a broader understanding of what women suffer at the in the workforce, what are the factors that exclude their participation from the workforce. And I quickly want to sort of note that this shift has happened over time. It has happened because the judiciary has taken a different stance, a different understanding of harassment. And in fact, in the Nadia Naz review judgment, which is critical, and you'll see how I cited in my paper, which is critical to this transformation and growth in the law. And we have Justice Aisha Malik here, who wrote that judgment. And in that judgment, she writes that harassment is not so much about sexual desires, but more so emerges from the imbalance in the power dynamic between men and women at the workplace. And this imbalance is what is responsible for creating opportunities and space for intimidation and discrimination against women. So this shift brings the understanding of the law to be more in line with the true purpose and spirit behind promulgation of the law. And number two, it reflects the actual lived experiences of women in the workforce. And just to note what kind of orders are coming out from relevant bodies after this shift. And we have Ms. Fauzia here, who is also responsible for pushing the law forward in this area. FOSPA has given decisions which have held that terminating a woman during her maternity leave is discrimination and amounts to harassment under this act. FOSPA has also given a decision that requiring the widow of a government servant to produce a no marriage certificate before she can be entitled to receive certain benefits, that is also gender-based discrimination and can be agitated under this act. So we have a broader understanding of what harassment means and what exclusion means, excluding women from the workplace, broadening the scope for actions that can be brought under this law, which is very important. Thank you.
Next, what the law was actually made to achieve became the suppression of dissent. And if you ask me for one provision, I think there are multiple provisions in the law that are problematic, but one is the extent of the power given to two authorities. The Pakistan Telecommunication Authority, which acts as the chief censor of online speech, and the second is the FIA, which has now been replaced by the NCCIA. They have immense arbitrary power under this law to both censor speech and also to investigate people for alleged offenses under this. Now, when I say arbitrary power, let me ask everyone here a question. So the Pakistan Telecommunication Authority under Section 37 of PECA has the power to ask any online platform to take down content that might be locally unlawful. From 2018 to 2019, do you know which country sent the most content takedown requests in the world to Meta Platforms Inc.? Pakistan. In the entire world. How many of you know what those requests were? We don't know. We don't know what they are asking them to block. The transparency reports that are coming from the social media companies are the only way we know. Right to information requests have been pending for a long time. We are not given that information. We are only told vaguely this much was removed for hate speech, this much was removed for glorification and terrorism. But the fact of the matter is, we don't know what they think is hate speech. We don't know what they think is terrorism. Now, what they have done is they have enacted Section 26A. 26A says, and again a pretext was used. This time the pretext was, we need to counter misinformation and disinformation, which is essentially fake news. But how they defined fake news is, they didn't define it. So anything can be fake news. Generally, if you look globally, when you try to regulate false information, and yes, it is a problem, it is often defined as a statement of fact that is likely to cause some type of harm. So I'll give you an example of that sort of content. Misinformation against the polio vaccine. That is something we can understand because it has also led to deaths of polio workers. It has led to consequences for children. But let's say I say the state is complicit in human rights violations. Under 26A, this is an opinion, yet it would still come under the ambit of 26A because there is no carve out for opinions, satire, humor, analysis, commentary. There are no carve outs. So the state has this absolute discretion now over the truth. And what we have done is we have made it a criminal offense. So the state can say, we don't think we're complicit in human rights violations. Arrest this person under 26A. And the NCCI has done this. The FIA has done this. We know because there's a case right now in the media of Iman Mazari and Hadi Ali Chatta. What did they say that was a false statement of fact? They gave opinions, but they have been imprisoned for their opinions. This sort of discretion is not only, in my opinion, unconstitutional because we must not forget that for all the laws that we have promulgated, Article 19 of the Constitution still exists. Now people may say it has restrictions. Yes, but we have also ratified the International Covenant on Civil and Political Rights. That means it is part of our local law. That means any restriction on speech must be judged according to legality, proportionality, and necessity. I assure you the PTA is not doing this, the FIA is not doing this, and the NCCI is not doing this.
Definitely. Thank you very much, Hassan. That was very informative, and I hope everyone here is reflecting on that. My last question would be for Ms. Nida Chaudhary. Nida, in your paper, multiple comparisons are made with the UK system. What concrete reforms would you suggest to make legal education more accessible, equitable, and in line with the global best practices?
Thank you so much, and thank you, Hassan. I mean, it does dim our light a bit because we are sharing this 10th anniversary with that of PICA's because that was also passed in 2016. But another very interesting thing that started happening around the early 2000s was that the Bar Council woke up to the fact that there's a mushroom growth of law colleges and that they needed to control them, and there's so many law students coming into the profession and there's not enough jobs and opportunities, and the quality of the profession overall is falling, and so there was all sorts of anxiety about what the law schools were doing, what kind of graduates they were producing, and so they decided that they are going to now involve the Supreme Court in the process of regulating legal education without having a single PhD in their ranks. And that's where I started thinking as to whose prerogative is it really to regulate something like legal education. I mean, just because you are from the bar, does that entitle you to be able to make decisions about to make decisions that should technically be part of the autonomy of higher education institutions? These are decisions like what curriculum to teach, when to have classes, how many number of students to they have the capacity to take in, how many, like the number of books in the library, for example. I mean, these are not the decisions that the Bar Council should be making for the universities. These are decisions by involving the Supreme Court in this and by taking a lead on this. I think what they have done is they have stifled the kind of diversity of programs that we could have had, or they've stifled the kind of opportunities that an autonomous university could have created for their students, because now what you have is a curriculum that they have prescribed, and they want it uniformly applied to all law schools, and they want to regulate, and they also want the students to pay a certain sum of money just because they're enrolling in a law school. Now, how many of those students don't even end up being active practitioners? They don't end up being members of the bar. They could pursue a master's and a PhD, or pursue some academic career or a career in research. They could take up any sort of they could do a CSS after that and do any government job, or be in foreign office, or work in international law or some international organization. But no, you have to pay a certain sum of money to the bar just because you've decided to enroll in a law school. And what do the law students get in return for that amount of money that they're paying to the bar? Nothing. Zilch. Zero. Because when you ask them to set up a fund to support the law students who qualify for international mooting competitions, they say that students are not within our jurisdiction, or that this is out of our scope. So, I mean, the kind of double standards I started experiencing, because I teach and I engage with law students all the time. And through Women in Law, they've been coming to us for help and for support. And every time, like when they qualify for mooting competitions, and I see that there is no governance structure, not at the university level, not at the bar level. And yet when it came to controlling what can be taught, controlling how many students a university can have. So the entire exercise, then you start questioning that. You start questioning whether A, bar is really the right forum to be doing this, how qualified they themselves are to be taking decisions on higher education matters, and also what impact that has on the autonomy of universities. And you asked about the comparison with UK, and I'd like to quote the Russell Group, which represents 24 leading UK universities, and it states that we believe a quality education, student choice, institutional diversity, competition, collaboration, and international competitiveness are built on a foundation of institutional autonomy. The freedom of universities to manage, teach, choose their staff and students, and that they are able to speak freely. The importance of that autonomy was recognized by the government's inclusion of it in the Higher Education and Research Act of 2017. Autonomy is also critical in enabling our universities to deliver for students across the Office for Students' fundamental objectives on access, quality, consumer law, and value for money. And I want to talk about access a little bit, because they've also made classes mandatory in a brick and mortar institution, whereas the world is moving towards digital forums. I mean, I've done the University of London degree myself, sitting here in Pakistan. Yes, I did go to a local teaching institution, but I could have done it simply as an external student from my home. But over here, we want to regulate that also. We want to make sure that we don't open the access for women or differently able persons who could have done this degree, but now they need to, in order for them to be able to enroll for their bar licenses, they need to be, present in a brick and mortar building in order to justify that they've earned that degree. So I mean, these are just quite, they're archaic ideas. I think that there is no space for such thinking. If we want to compete with the global community, we need to open up these spaces, and we need the bar out of legal education. What they can do at their level is to institute a proper bar vocational course, as it is in the UK and other jurisdictions. But at that level, there's not much institutionalization. There's just been few sporadic efforts by individuals like Muhammad Ahmed Qayyum, who's done a lot to get a bar course started at the bar, but that's a 2-week course which is lecture based, and even the bar's own exam is an MCQ based exam. It hardly, and it gives you 7 to 8 chances to appear. The pass percentage is very low. So I'm really not sure why they're not putting their own house in order and interfering in the institutional autonomy of universities. Thank you so much.
Thank you very much, Nida. All very good and important points, and I think all the students here in law can appreciate that and probably have thought about those issues throughout their journeys and also had to face them. So hopefully we can change that around. And if you guys all enjoyed Nida, Hassan, and Sahar's comments and critiques, you can find them in the Tracing Transformations in Law book at the back, booth number 2. Just before we end here, I'd like to call up Ms. Fauzia Waqar for her comments and closing speech. Thank you.
Thank you. First of all, congratulations to Women in Law for their 10 years. Must be a difficult journey considering that the gender perspective that we talk about so much is really absent, and it's a struggle, an uphill battle. I'd also like to appreciate and thank the contributors of the book Tracing Transformations in Law. Good, insightful book and easy to understand, relatable. I'd encourage all of you to read that. I'll begin with thanking our panelists for 3 very rich, rigorous and thought-provoking interventions. And what this panel had to offer us was not just simply a discussion of 3 areas of law, but a deeper reflection on how law in Pakistan is evolving, where it is succeeding and where it is under strain. For example, one of the most important insights of Sahar's analysis is the shift from understanding harassment as isolated sexual misconduct to recognizing it as a form of gender-based discrimination. This shift matters profoundly. It moves the conversation away from individual wrongdoings and towards structures of power, exclusion and inequality that shape women's experience of work. And that is a massive shift, because in my everyday life, when I deal with matters of harassment, it's very hard to make people understand the systemic realities which discriminate against women in the subtlest of manners, which is hard for a person, especially a person of the opposite gender, to understand, because it is not their lived reality. So having a good law and that law evolving matters a lot. When harassment is framed as discrimination, it is no longer treated as an aberration or a personal grievance. It becomes a question of dignity, equality and access, anchored in constitutional values under Articles 14, 25, 27, 34 and 37. And I really appreciate the role of the judiciary in invoking all those guarantees of not only constitutional equality, but dignity and inviolability of dignity of a person, as well as non-discrimination in employment, the need to have better representation of women in public spaces, etc., to anchor harassment law in these constitutional guarantees. Importantly, the trajectory of harassment law does not just reflect regulatory access or overreach, but it moves to a paradigm for introducing that enabling and safe workplace. It responds to a long-standing absence, a legal absence. And the 2022 amendments, for which I'm personally very grateful because they're coming in handy every day, they represent a corrective expansion, addressing forms of exclusion and invisibility that had legally gone unrecognized. Here, the challenge has been belated recognition and effective implementation, not restraint. An important point that I culled from reading Sahar's chapter was the evolving relationship between the judiciary and the legislature in shaping this regime. The law has developed through a form of institutional dialogue, sometimes uneven, sometimes contested, but ultimately oriented towards giving substantive content to dignity at work. It reminds us that progressive legal change often emerges incrementally through institutional engagement rather than grand legislative moments. And I'm happy to see that we've had similar examples in, for example, Anti-Rape Investigation and Trial Act of 2021, where the law has evolved through this institutional dialogue, through a feedback loop, not only from the legal community, but the civil society. And it has had incremental improvements like the Rawalpindi rape case in 2013 and the various institutional provisions that were introduced in that as guidelines, to the banning of the two-finger virginity test by Justice Aisha Malik, who is sitting here amongst us, reported in 2021. And now we have other opportunity for this institutional dialogue and this feedback loop. I feel strongly in the Elections Act also of 2017, because the recognition, although belated, is there that the law can help increase representation of women, but much more needs to be done to counteract the challenges that come from giving women token representation on general seats. Hassan's chapter on PICA represents a different and unfortunately gloomy picture. Because while this law was enacted as a law of protection against harassment, digital harm, etc., but he shows that it has that increasingly the law has functioned as a tool for controlling speech and centralizing power. He gave really good examples of how two institutions, the Pakistan Telecom Company, PTC, as well as the NCCIA, have assumed arbitrary powers to completely turn this into a draconian law and chill the freedom of expression that we so work for and for which there are constitutional guarantees. This law and the analysis that emerges from it tells us that the shift is visible not only in particular provisions but in the enforcement practices that have concentrated power in the state institutions. And the speech is chilled not through convictions alone, but through uncertainty, surveillance, and asymmetry of power between the state and the citizen. Finally, Nida's chapter, I feel like, brings it all together. It draws our attention to a foundational but often neglected question. How are lawyers formed? And I think she's given us an understanding of how lawyers are getting formed these days and who gets to participate in the legal profession. Her analysis, I feel, of the Pakistan Bar Council legal education rules demonstrates how a framework introduced in the name of quality control has, in practice, raised barriers to access, constrained university autonomy, and standardized legal education in ways that sit uneasily with global best practices. The comparative references from the UK are not calls for transplantation, and I assert that very seriously, because often whenever something good is done and a best practice is adopted from another country, it is castigated as transplantation, unsuitable to the cultural realities of a country. So she's not calling for transplantation. These are invitations to think in terms of principles about accessibility, diversity of pathways, and respect for academic governance. What is at stake is not merely pedagogy, but the intellectual character of the legal profession itself. And her warning is a serious one, that excessive regulatory control risks producing lawyers trained primarily in compliance rather than critical thought. This again is a very important point, because in my dealings with lawyers on an everyday basis, I see that being translated into arguments, into thought patterns which are essentially discriminatory. And I'll give you some examples, and I think Sahar also mentioned about some of the decisions that have come out of FOSPA. When a prejudicial mindset is talked about, for example, by the vice chancellor of a university, the rest of the university and the lawyers representing them do not understand that it is squarely covered under the law, and it is that prejudicial mindset which ends up in discriminatory practice against a woman, who will end up not getting promoted because of that discriminatory mindset. Similarly, for example, even beneficial legislation such as putting a cap on a woman's ability to contribute under the employee's old age benefit insurance at 55, while seen as a beneficial action so that she can claim eligibility at an early age, and may end up discriminating against her because her ability to contribute for 15 years is seriously compromised, Similarly, Sahar talked about the Prime Minister's family assistance package, made for a good cause, but says that a woman, if she gets married, if she has a job after the death of her husband, when she gets remarried, she has to give up her job, otherwise she doesn't have to marry, So the choice is between her keeping her job or not being able to marry. And that is a difficult choice to make. And the underlying message is that a woman should always be dependent on another man. So now that she's found another man to rely on, the job is taken away from her. I have multiple other examples. For example, recently I came across the practice, not the law, but the practice of denying rent of a building to single women and men. Now we know that this goes against constitutional guarantees of equality, but it is accepted in the name of protection from terrorism, protection from prostitution, without clarifying that those are actions that they are illegal, that should be prevented. But you can't deny an opportunity to a woman, for example, who's come from Karachi to Lahore to rent a building, and that single denial is going to shape perhaps the rest of her life. Important issue to make. Or excessive CCTV monitoring for purposes of sexual harassment in this case. So I think I should wrap up. Across the three contributions, a common concern emerges: the relationship between law and institutional power. Women's trust in workplace mechanisms, citizens' trust in digital regulation, and students' trust in professional governance are all shaped by law by how institutions exercise authority. Law can either repair that trust or erode it further. Protection can empower, but it can also discipline. Regulation can ensure standards, but it can also silence. What we need now is that to understand that while in some areas, such as workplace harassment, the work of the law has been to catch up with lived realities, but also to understand that particular digital regulation and professional governance has had the effect of pulling the law back into alignment, into non-alignment with constitutional limits, and that is where we need to move. Let me conclude by thanking our panelists for scholarship that does not offer easy answers, but it asks the right questions. These chapters remind us that law is not merely a technical instrument, it is a living conversation about power, dignity, and justice. Thank you very much.
Thank you very much, Ms. Fauzia. That was very nice and very well way to wrap everything up and conclude it. We weren't planning on it before, but because it affects a lot of people in the room, we wanted to have a quick Q&A. If anybody has any questions for any of the panelists or the panel chair, please raise your hand and we'll give you a mic.
My name is Aisha Ayub, and I head the complaint cell at Human Rights Commission of Pakistan. So my question is for Hassan. Can the PICA law be applied retrospectively, because the book, The Case of Exploding Mangoes, has been translated into Urdu, and it has been literally, earlier the people were being picked up, now the book has been picked up. So what will happen, like, to what is now, how will this law be applied?
So thank you. So in terms of, as you know, the Constitution prohibits retrospective punishment. But the way the PECA works is the internet is a different sort of beast, right? It's not like a published book. If today certain passages of The Case of Exploding Mangoes was to be published on the internet, on social media, could the PTA send a request to a social media company that it be taken down? Yes, it could, because it would be published today. Now, what would be the basis upon which it would send a request for a work of fiction is the more important question. Now, The Case of Exploding Mango specifically says that it is a work of fiction. So that means it's not fact. So it could not be fake news. But 6A, as I already told you, is so broad and vague that even a fictional piece could fall within the ambit of the offense itself. And I wish this was just an academic or theoretical thing that I was saying. People could say, oh, but that's not how it's being enforced. We know that is how it is being enforced. I also know from my experience working at social media companies that that is how PECA has been enforced. Memes are reported. For what? On what basis? You and I don't know. Transparency, which is the fundamental aspect of democracy, is being undermined because we don't know for what purpose a lot of these laws are being used. Now, let me tell you, Aisha, one particular thing about, it's not just an issue in the law. You know, sometimes we focus too much on, okay, repeal the law, maybe things get better. It's also an attitude problem. It's also a thinking and mindset problem. In my chapter, I start out by saying that in 2016, when PECA was first introduced, I was invited to give talk, an overview on it, a institution. And one of the speakers was a former member of the FIA. And I spoke about all these concerns that PECA raised, that it won't protect women, it will be used eventually to curb dissent. And when the individual from the FIA spoke, it was him saying that, you know, all these things that you say about free speech and constitutional rights, they are all well and good when we are at peace. Right now we are at war because the APS attack had just happened. And so there is a sense of insecurity dominating Pakistan that causes everything to be justified, every fundamental rights curtailment to be justified in the name of security. People say we are a security state. I don't think that's correct. I think we are an insecure state.
Thank you very much, Hassan. Anybody else? G?
So thank you so much, the panelists, for this very enlightening discussion. I have a question for Hassan for you. As you, I am sure that you must be aware of the fact that with the recent PICA amendments, the implementation authority has been shifted from MOIT to the Interior. That makes the situation more worse. So we have been like in discussion with at the federal level with regard to this, and this has become a very sensitive issue. When we are looking at from the lens of technology facilitated gender-based violence, it becomes more imperative to see and distinguish between the PICA law and its effect on the gender, and again how it is being used. We have this evidence. So the thing is that now the discussion, we are just waiting for a report, evidence-based report that we are expecting to be launched in March. The support of UNDP on the technology facilitated gender-based violence. So the issue now is that we have to distinguish between the gender-based violence, how it is being treated under PICA, and to have another legislations. So I just want to know your thoughts, and I would like to invite women in law to this discussion that we will be soon initiating at the NCSW.
Thank you so much. That's a very, very good question. So I think the first thing we need to understand is social media should be regulated. I do not deny that. Women should feel safe on social media. Children should be safe on the internet. Everyone should feel safe. I think the approach that we get wrong is that we treat everything that we dislike and try to make it a criminal offense. So we focus too much on using the coercive apparatus of the state. Now, if you look at other countries who are tackling with similar issues, what they are doing is, instead of creating criminal laws where every time you see something you have to send it a company, wait for them to get back and they down or so on, they are shifting to what we call a systems-based approach. What that means is they put certain obligations on social media companies where they have to commit that we will give you, let's say, annual reports that will say, this is how we tackled harassment against women in Pakistan. This is how we tackled child safety in Pakistan. These are the policies we implemented to tackle child safety in Pakistan. And when we move towards in that direction, look at Australia. Australia has created a specific institution for online safety. It is headed by an expert who is a former counsel for Google. I think the problem is neither in the PTA or in the NCCIA, and frankly speaking, I have seen in consultations that actual genuine expertise over the online sphere is not asked to participate. When we used to go into consultations with the government, they never used to invite Bolobi, DRF, Media Matters for Democracy, Women in Law. These are the people who can tell you how to best protect women online. Now, there were some good amendments made in PECA for child safety, but that was because it was a very good participatory dialogue on child safety that happened. We must look at alternative methods. So when I spoke about misinformation, everyone agrees misinformation is a problem, right? It's a criminal offense. Now, I'll give you another example of an alternative model. So, for example, Singapore and some other states, what they do is that if they believe there is false information on the internet, they ask social media companies to label it. And next to the post, it will say, the government of Singapore believes that this information is not accurate. For accurate information, you can go here. Now, what does that do? It prevents the criminal offense. It prevents the chilling of speech, and it also gives people an alternative to find out the truth. So I'm not saying this is but what I'm trying to say is alternatives exist beyond criminalizing every single speech.